Hi, I'm Gabe.
Hi, I'm Jake.
Hi, I'm Daniel.
Hi, I'm Nina.
And I'm Xiomara.
Welcome to Ethically, emphasis on the Lee. On Ethically, we discuss complicated issues of professional responsibility. Today, we'll be talking about the duty of confidentiality. Specifically, we'll be going through Model Rule 1.6, the confidentiality of information, and discussing a few real-life cases that display the duty of confidentiality problems.
Rule 1.6a says that a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. You guessed it, listeners. Paragraph B contains exceptions to the duty of confidentiality. Why don't you tell us about the exceptions, Gabe?
Sure. Rule 1.6b says that a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary to prevent, and then the rule provides a long list of exceptions. Most importantly, the rule provides exceptions to prevent reasonably certain death or substantial bodily harm, to prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interests or property of another, to prevent, mitigate, or rectify substantial injury to the financial interests or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud, and to establish a claim or defense on behalf of the lawyer.
So, it looks like there are a lot of very specific exceptions in Rule 1.6b that give the lawyer the option to disclose information. Because the exceptions are so specific, the lawyer should take great care to determine whether or not an exception applies before disclosing information and err on the side of non-disclosure.
That's right. It's always better to err on the side of non-disclosure when in doubt. Finally, Rule 1.6c makes a general statement that a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. So, what does this all really mean?
I'll tell you, Gabe, it means that the duty of confidentiality is a rule that should be taken very seriously. Clients should feel like they can disclose everything to their attorney. If the lawyer was forced to disclose everything the client told them, then no client wants to tell their lawyer anything. This would provide all sorts of problems for the client's due process.
So, is the attorney-client privilege the same thing as the attorney's duty of confidentiality to his or her client?
That's a great question. The attorney-client privilege is not the same as duty of confidentiality. The attorney-client privilege is narrower in scope than the duty of confidentiality. The attorney-client privilege comes from the laws of evidence and gives the client a legal right to prevent a witness from revealing confidential communications between the client and his or her attorney. The duty of confidentiality, on the other hand, applies to all information relating to the representation of a client. This distinction is important because it highlights how broad the duty of confidentiality is. If the client tells his or her lawyer something, the lawyer must keep it confidential, although there are the narrow exceptions to the rule.
Okay, now moving on to a real-life example. This example shows just how serious the exceptions to the duty of confidentiality should be taken. We found this story in the Journal of the Legal Profession.
This is the story of Alton Logan. Logan was a criminal defendant accused of murder in 1982. After being convicted of the offense, Logan received a life sentence in prison. Two criminal defense lawyers, Dale Coventry and Jameson Coons, represented an unrelated criminal defendant who was also incarcerated for life for an unrelated murder. Their client, Andrew Wilson, had admitted to them in confidence that he committed the murder that Logan was tried and convicted for. The lawyers felt that the rule of client-lawyer confidentiality tied their hands, and they could not disclose the information that could clear Logan's name.
The problem was that Logan was not sentenced to death, and therefore the lawyers did not have the option to disclose because Logan was not at risk of certain death or substantial bodily harm. Thus, the situation did not fall under the Rule 1.6b1 exception. Eventually, the lawyers received permission from their client to disclose the exculpatory evidence, but not until their client had passed away. Logan was finally released in 2008. Even if the lawyers had reasonably believed that someone was at risk of bodily harm, they would not be required to disclose that information, only permitted to do so.
Wow, this case really shows just how serious the duty of confidentiality is and the intense real-life implications it can have on people's lives. If you are ever in doubt about whether you are allowed to disclose something, be careful. Thanks for listening to your favorite new podcast, Ethically.